All right, it's Monday morning now, and I need to find out from you what your intention is with regard to whether you are going to testify in this case. You have been granted immunity so that the privilege of self-incrimination is no longer relevant because the state can't use anything that you might say in answer to their questions or any other questions against you. And you have been instructed with the benefit of counsel as to the consequences if you don't testify. So I'm asking you now what your intention is.
May I speak?
You can answer my question, please. And so you're under subpoena. The state intends to question you. Are you going to answer any of those questions? Are you going to testify in this case?
Well, Your Honor, I've been pressured from the get-go. You know what I mean? Like, even when I went to the meeting with Glenville, I have told him over and over and over and over. You know what I mean? This is on my conscience. I got to keep distracting myself every day because I'm being dragged down to here because of lies that I don't told. I'm tired of y'all bothering me.
Okay, well, I'm sorry that you're tired of being bothered, but you're under subpoena. It's a valid court order. So your decision at this point is, yes, I will abide by the subpoena and testify, or no, I will not abide by the subpoena and the immunity order, and I will be held in contempt for my refusal and put in jail. So which is your decision?
But I did the time for all my crimes that I was caught for.
Sure, this would not be any kind of punishment for any crimes you may or may not have committed. This would be that you have been ordered by a court to testify, and if you refuse to testify, you're held in contempt. You're saying, I refuse to listen to the court's order and obey it. And it is not a punishment, it is an incentive to have you change your mind and obey the court order. So which is your decision?
Can you explain that to me?
So we talked about it.
It's the same thing that Glenville doing to me?
It is the same order that is still in control. You have a subpoena for your testimony. That is a court order. You also have a court order that says anything that you say can't be used against you other than if you get on the stand and lie and it amounts to perjury, you can be charged with that or with false statements. But if you refuse to testify altogether, when you're under a court order to do that, then that is considered contempt because you're saying, I don't care what the court has ordered, I'm not going to do it. And then you'll be put in jail through the end of this trial. Or until you decide, you know what, I think I will testify after all.
So let me, Yana, I'm telling you to your face, you just said that something about it, they can lock me up for lying. I'm telling you to your face, this is all I do. And you're telling me that they can lock me up if I lie. But if I sit here and testify, so the either go, I'm going to jail.
No, not with regard to anything that you might testify to that might otherwise admit to a crime or admit to your involvement in a crime. That's what the immunity order does. And I'm sure Mr. Melnick has explained this to you, and I know I've explained it previously, but none of that is going to result in you being put in jail because they cannot use that evidence against you to prove any of those crimes that you might incriminate yourself about. So are you going to testify or not? Do you want to talk to Mr. Melnick again? No? Okay.
All right.
Okay. All right. Thank you. All right, so I'm going to have you step out for just a minute while we get the jury in. Mr. Melnick, if you could step out with him, please. Just so. Thank you. Yes, ma'am. I am. I was gonna see if anybody had anything to say first.
Your Honor, I'm going to renew my motion for a mistrial based on coercion by Judge Glanville. This is based on the fact that Mr. Copeland, having now clearly instructed that he would only be incarcerated until the end of trial versus his instruction previously that he would be incarcerated forever. He's now deciding to testify. I think at this point, it demonstrates the coercion by Judge Glanville. So I'd like you to reconsider that.
All right. I don't think it just demonstrates anything of the sort. I think it demonstrates that he's now been properly advised and he's making a decision anew. Thank you. Overruled. Yes.
Housekeeping matter. Is the Harvey rule still under your guidance? Still in effect? Okay.
Yes, it is.
Thank you.
Okay. And so I'm going to have the jury out. I'm going to give them the 3 instructions that we just discussed. Then we'll have Mr. Copeland in. I'd like him resworn, and then you can pick up from whatever you want to do post June 12th.
And Your Honor, may I just step outside to see if Mr. Melnick has informed Mr. Copeland that there's going to be some testimony he's going to have to repeat. My interactions with Mr. Copeland, he'll get frustrated.
Okay, you know what? Why don't you, instead of you going to talk to anybody, just can I have Mr. Melnick in again?
Yeah.
Real fast. That's a good idea, though, to tell him that. I don't know if he's been told that or not. I don't think Mr. Melnick was in here this morning when we were discussing the directions or the instructions.
Just while we're waiting, you're going to bring them in after you give the instruction and the excuse.
Certainly. Yeah. Mr. Melnick, I just wanted to make sure, because you weren't in here this morning when we were discussing it, and you may or may not have been in any of the times we were discussing it, but we are going to be essentially redoing everything post-recusal motion, and I didn't know if Mr. Copeland was aware of that or not. So some of the things he's going to feel like, man, I already said this once, but he's going to have to say it again because I'm telling the jury disregard a lot of the last few days of his testimony.
So I believe he's aware of it.
Okay.
As far